All right, good afternoon, everyone. It is shortly after 1 p.m. on Tuesday, February 24th. Starting off our week here in House Government Operations and Military Affairs with H-103, an act relating to prohibited practices for services involving veterans benefits. We're going to start with Legislative Council. There's been a lot of work this over the past weeks, if not months, by Representative Morgan and other interested parties. So you're going to hear from council on what the new words on the page look like. How are you, council?
Good afternoon. Sophie Zadatny for the Office of Legislative Counsel. And I'm just waiting for permission to share.
We love that. I was telling you that. I'm just on the way in.
Yeah.
Yeah, totally. Got some thoughts, kid? Yeah.
Didn't get right back by the trip.
Talking to Jay earlier. Right.
Council, the table is yours.
Okay. So before I walk through this, let me just quickly do a quick recap from the bill that was introduced last session. So that bill was to prohibit folks that are not accredited by the Veterans Administration to provide assistance for benefits veterans. This bill is different than that was, so I just want to make sure that's understood up front. There is, under federal law, it is actually illegal for folks to help veterans with benefits and charge them compensation, but there's a loophole in the law. So a lot of companies have started providing assistance to veterans to help them get their benefits, but for compensation. So essentially what this bill would do is it would provide some guardrails around those folks. So I just want to be clear that people understand this is a different bill than the one that was introduced last year. This is now looking at making sure that those companies that do assist veterans, there are some guardrails in place. So I just wanted to make sure everyone was clear on that. This is quite a different bill. It's still looking at consumer protection. If there are violations of the bill, that hasn't changed. They would still be looking at our Vermont consumer protection laws to follow up on any violations of this bill as drafted. Let's hop on it. So I have not highlighted the bill because there really were sort of too many changes. So I'm going to go through them, but it's not highlighted because it's quite different. So again, the intent has now shifted. So it's the intent of the General Assembly to regulate the practices of persons seeking to receive compensation for advising, consulting, or assisting any individual regarding a veteran's benefits matter as defined in this chapter, and to protect veterans, their dependents, and survivors from unfair and deceptive practices. Under the definitions, 1752, definitions 1 and 3 have not changed, but this adds in the definition of a person. So under state law, a person is a natural person, but it's also a corporation or a business. And rather than being repetitive throughout the bill on carving out organizations that are officially recognized as accredited agents and attorneys, this just puts right in the definitions that person does not include those folks. So a person means any natural person, corporation, partnership, or other legal entity that but for purposes of this chapter, a person does not include an accredited representative of a recognized organization or an accredited agent or attorney pursuant to the federal regulations. So as you go through this, just be aware there's that carve out. So this is dealing with those entities that are not accredited by the Veterans Administration. And then there's no change to the veterans benefits matter definition. Under prohibited conduct, some of these were in the previous bill and then some have changed. So prohibited conduct is that no person shall act as an agent or attorney with respect to a veteran's benefits matter unless the person has been recognized for such purpose by the Secretary of the U.S. Department of Veterans Affairs, right? So that's what we understand the case to be. No person shall receive compensation for referring individuals to another person for advice, consultation, or assistance with regard to any veteran's benefits matter. No person shall guarantee either directly or by implication that any individual is certain to receive specific veterans benefits or that any individual is certain to receive a specific level, percentage, or amount of veterans benefits. And then this is a new piece here. No person shall use an individual's personal login, username, or password information to access an individual's medical, financial, or government benefit information. I would just add in here that some of the changes that are incorporated into this bill are based on a Tennessee law that was passed in 2025. And there is some differences between them. And one of them is that under the prohibitions under the Tennessee law is that you won't use, I think it's an international calling center, for veterans, handling veterans affairs. So there may be something else you might want to consider from the Tennessee bill to include in here, but was not part of this. 1754, so this is where these kinds of guardrails are in place. So, and really providing transparency for the veterans because, or their family members that are eligible to receive these benefits, to make sure that they understand, what they are dealing with here. So this provides any person advising, assisting, or consulting with an individual on a veteran's benefits matter shall provide the individual with the following written disclosure prior to entering into a business relationship. And so this disclosure really spells out that the business is not sponsored by or affiliated with the U.S. Department of Veterans Affairs, the Vermont Office of Veterans Affairs, or any congressionally chartered veterans service organization. This business does not act as your agent or attorney with respect to your veterans benefits matter and does not represent you before the U.S. Department of Veterans Affairs. And then it explains that other organizations such as the Vermont Office of Veterans Affairs and congressionally chartered veteran service organizations may be able to provide you with this service free of charge. Products or services offered by this business are not endorsed by the U.S. Department of Veterans Affairs, the Vermont Office of Veterans Affairs, or a congressionally chartered veteran service organization. You may qualify for other veterans benefits beyond this benefit for which you're receiving assistance from this business. And then in subsection B, this provides that the written disclosure that's required be printed in not less than 12-point boldface type of uniform font, and that the individual seeking assistance with the benefits matter has to sign the document containing the written disclosure, acknowledging receipt of the disclosure. And then the person who's providing the assistance, the services, they would retain a copy of the signed written disclosure for at least 1 year following the termination of the service relationship. And then subsection C requires that the services be memorialized, all the terms be memorialized. So a person seeking to receive compensation for advising, consulting, or assisting an individual with a veteran's benefits matter shall, before rendering service, memorialize all the terms regarding the amount of payment for services to be rendered in a written agreement signed by both parties. Subsection D puts a cap on compensation. So compensation for services rendered shall be contingent upon the individual receiving an increase in the amount of veterans benefits awarded. So if there's no increase, there would be no payment made. A person advising, consulting, or assisting on a veteran's benefits matter shall not charge an initial fee, and a person shall not charge an individual more than 5 times the amount of the monthly increase in benefits awarded on the veterans benefits matter claim. So, for example, if somebody gets an increase of $1,000 in their monthly benefits awarded, they would then be paying $5,000 to the entity that's assisting them. This is a new section, 1755, providing for a background check that any person advising, assisting, or consulting on veterans benefits matters shall obtain a criminal background check. And then it cross-references to 21 VSA section 495J, which lists out when you can request information about someone's criminal background. For each employee who has access to the medical or financial information of any individual receiving such services prior to the employee having access to such information. And then the bill concludes with section 1756. And again, this bit is unchanged. This is a reference back to the consumer protection statutes in Title IX. a violation of this chapter is deemed to be a violation of 9 VSA 2453, and the Attorney General or a state's attorney has the same authority to make rules, conduct civil investigations, enter into assurances of discontinuance, and bring civil actions, and private parties have the same rights and remedies as provided under 9 VSA Chapter 63, Subchapter 1, and then the date has been updated to be go into effect this July 1 of 2026.
Okay. That's the run-through committee. Any questions for council? Rep. Stone.
How precisely will the term veterans benefits matter be interpreted in practice? Like, will that also include things like helping with an online application or?
So this is a definition. There have been a number of states that have been looking at passing laws like this. And this is kind of the sort of standard general language that's being used. It's very similar to what's in the Tennessee bill as well. So it's the preparation, presentation, or prosecution of a claim affecting an individual. And again, an individual, it might be not just the veteran, particularly if he's deceased or whatever. So an individual throughout this bill is referring to someone that's seeking to obtain veterans benefits. So this would be who's filed or expressed an intent to file a claim for a benefit program, service, commodity, function, or status. To be honest, I don't remember exactly where this language came from, as it's been probably 18 months since this was initially drafted, but this is sort of the general language that's being used in these statutes. I don't remember which specific one this came from. Are you concerned it's not comprehensive enough?
No, I was making sure it was. It looks like there's stuff listed there, like the program service. Just so that we're covering all of the bases so that people can't weasel out and say, oh, it wasn't a benefit. I was advertising a service that may, just making sure it's tight enough. And then in the disclosure requirements, is there standard language that's either proposed in this bill or you've seen from other states who passed the bill to avoid confusion among service providers?
So this was the language that was requested that is largely drawn from the Tennessee bill.
Okay.
That passed. And again, I think the goal of these guardrails is to make sure that if someone is using a service to access benefits, that they fully understand what they're getting into. So I think that's the purpose of the disclosure, to make sure it's as transparent as possible.
Any other questions from the table? No, thank you very much, council. So I want to shift next over to one or both of the sponsors of the bill. If you just wanted to offer any suggestion or just any feedback on the process and your sentiment on the changes. Yeah. Would you like to join us, sir?
I don't have much to say other than
Okay.
I've looked at the changes. Fine with them. They meet the initial bill that the two of us submitted. It goes a little further than what we had submitted. It adds to what we actually. I'm very appreciative of the committee taking this up, as well as Representative Morgan. Thank you very much on behalf of all veterans that help support.
No, thank you for that, Representative. So now for interested parties, I have Josh Diamond and John Bloomstrom. How you gentlemen doing?
Good afternoon.
Chairman, good afternoon.
Joshua Diamond for the record, and
John Bloomstrom for the record.
we'll be both here on behalf of Veterans Guardian. I'll turn it over to John for comments.
Thank you. Chairman Byron, members of the committee, want to thank you for the opportunity today to provide testimony in support of H103. As it stated, my name is John Bloomstrom. I'm a United States Marine Corps veteran. I currently work in the veteran benefits policy space on behalf of Veterans Guardian. Veterans Guardian assists and guides veterans. They submit their initial disability benefits claim at the United States Department of Veterans Affairs. We provide a passionate team that is focused on serving our nation's veterans. I appreciate the thoughtful engagement from Representative Morgan, Representative Page and Labor, and Mr. Burke of the Vermont Office of Veterans Affairs. This collaborative approach taken here reflects the seriousness of this issue and the shared goal of protecting Vermont's veterans. H103 with its proposed amendments provides meaningful consumer protections while not eliminating options. The bill with the proposed amendments establishes consumer protections for any business that chooses to operate in the veteran benefit space, including no upfront fees, compensation only if there's a successful increase. And where I want to be very clear about that is that providers like ours that work ethically and in the best interest of the veteran ensure that we are not leaving a veteran worse off than when they came to work with us. If we are not successful in a veteran getting an increase, we do not charge them anything. If a veteran cannot afford to pay us, we work with them on any payment plan. So again, we are focused on ensuring transparency through disclosure and ensuring that a veteran knows all of their options to include the free services. In fact, I want to be very clear about this. We implore them to use the free services before using a service like ours. It's very important that they know that free services are available. That we actually tell them to go and use those services before picking up a service like ours. We want us to be the last option, not the first. We also require clear written agreements, disclosure of the free services, prohibitions on misleading representations, privacy protections, and background checks. Enforcement through Vermont's consumer protection framework. We feel that these are reasonable and substantive protections. I want to be very clear also here that the VSOs are the free services veterans are encouraged to use. As amended, H103 would require providers like ours to disclose to a veteran that said free services are available. And again, according to the data of Vermont's VSO capacity, approximately 9 VSOs statewide, serving roughly 4,300 veterans per representative with over 1,100 pending claims, 40.9% claims pending longer than 125 days. I say all that to say this. When veterans encounter delays or complexity, some choose to seek additional assistance. That choice should not be prohibited or categorically eliminated. It should be regulated to protect veterans. H103 is amended to achieve those twin goals of providing consumer protections and choice. There's been discussion nationally about whether private assistance violates federal law. The governing statute restricts veterans who act as an agent or attorney, and this distinction is critical. Acting as an accredited agent or attorney is federally regulated. Providing preparatory assistance or advising support without acting as an agent of record is not prohibited under current federal statute. H103 represents that boundary. It explicitly carves out accredited agents and attorneys regulated by the U.S. Department of Veterans Affairs, and it does not attempt to interfere with federal accreditation. It does not redefine a federal authority. It simply regulates consumer conduct within Vermont. What this bill is and is not. What it does not require a veteran to pay anyone. I want to be very clear about that. It does not eliminate free services. It does not undermine the VSOs. And more importantly, it does not interfere with accredited attorneys, ensuring that those options are still first and foremost available to Vermont veterans. What it does is protect veterans from bad actors, preserve freedom of choice, require transparency, impose accountability. And this bill recognizes reality. Some veterans file alone, many use VSOs. The answer is not to eliminate one pathway. The answer is to regulate responsibly. H103 is a thoughtful, balanced approach that protects Vermont veterans while providing meaningful choice in the marketplace. I respectfully urge your support. Thank you for your time and commitment to Vermont's veterans. I'll conclude with saying that I really appreciate the time today, but I also appreciate those on this committee who have served both in and out of uniform, and appreciate the time and opportunity today to speak before you. Thank you.
Thank you. Any questions for our guests on their perspective and role within this conversation? Seeing no hands. Thank you for the time, and if anything, yes.
Mr. Chairman, thank you. Thank you, Colonel.
Definitely refer to the gallery if anything pops up for you. Next, Ray Poulos, please.
Just wait and support.
Waving in support. All right, that was a very efficient utilization of table time. Thank you, sir. Mr. Burke.
I'm gonna get his phone now. Always a drink. Good afternoon, everyone. Robert Burke, Director of the Vermont Office of Veterans Affairs, for the record.
So I work closely with Senator Morgan and Woodman to look at different modifications and improvements to this bill, all of which have come out in the final version, I guess, let's say. So the data presented is correct. I have 4 service officers and they are carrying about 1,100 cases per. As they everywhere from taking POA, doing an intent to file, all the way up to a decision, appeal, possibly. Yeah, and it is long, the long and winding road. I think that this strikes a balance between regulation and consumer protection. I think it's a compromise. A lot of it is, as Ledge Council said, taken from the Tennessee bill. So a lot of the verbiage that you see in the legislation from different states is very similar. It does provide an avenue for people who are not accredited, who are not agents or attorneys and certified by the United States Department of Veterans Affairs to advise and assist in veterans filing claims, not to file on their behalf, not to have access to the records system, benefit management system that the federal VA runs. So they are consultants, advisors. And I think that's, as Ledge Council broke out, it's a bit of a compromise because the federal statute is very clear on accreditation and the ability to represent individuals, veterans, or their surviving spouses, family members before the Department of Veterans Affairs. So I am in support of it. A lot of other states have chosen to prohibit. But just for an example, Louisiana's recent attempt was struck down by its Supreme Court as being unconstitutional and not allowing companies the ability to advise and assist. So that's just a piece of data.
Yes, Representative Moore.
And a clarity / sort of a question to both Bob and John is that in the end, utilizing, for instance, Veterans Guardians Assistance, you all don't submit the claim.
No.
They advise, well, give your spiel on
Yeah,
that.
I mean, the long and
Just so
short,
y'all hear
and
that.
Mr. Burke is right. The Louisiana law was a little overreaching and violated the supremacy clause as well as what's the wording? Supremacy clause. Yeah, there we go. And the fact that the Louisiana law forgot to carve out accredited agents or attorneys. And so as a result was deemed unconstitutional. The consumer protections were not, but the fact that the Louisiana law neglected to carve out and tried to govern federal agents or attorneys was what the court deemed problematic. So we're fully in support of that law, being struck down because again, these consumer protections should not apply to accredited agents or attorneys. And Mr. Burke is absolutely correct in that.
But when the day is done, you all advise, assist,
Yep.
but the veteran's still responsible for submitting it themselves.
That is correct. Yes.
Just want people to be clear on that. They don't assemble all the papers and go, here you go, Department of Veterans Affairs. The onus is still on the member or the veteran.
They're there as a resource to guide the process, but the responsibility to put the request forward is still exists within the hands of the veteran.
That's credibility. Yeah, just want to be clear on that people didn't come away with the understanding that they would be this, unlike BSOs will orchestrate, help you assemble and go, yay, verily, here you go, Veteran Department of Veterans
Because my
Affairs.
service officers are accredited through the VA to take power of attorney and then represent those clients, power of attorney, fully through the process up to and including appeals. And then we use it's a group down in Virginia and NVLSP. And so they are lawyers that if you get to the Court of Veterans Appeals point, you want a lawyer.
Correct.
Yeah.
Period.
Oh, yeah.
You don't want a service officer. You don't want an advisor. You want a lawyer.
And you actually just beat me to my power of attorney question, so thank you for that. Yeah. All right, it seems like all of the interested parties are agreeable right now with the amended language and the proposal. So thank you everyone for everyone's work on this. I know there's a lot of effort that went into this, so across the board, I just want to say I'm appreciative. Any other questions for Mr. Burkett? Okay. So I guess that's where this leaves us with this one is, we have some time between now and its next scheduled conversation, which I believe is Friday morning at 10:45 for a committee discussion and vote. So that gives us a little bit of time to marinate on it, but what I'm hearing from everyone, this seems pretty crisp for us to get it out the door this week.
Yes.
Representative Boyd.
Would it make sense to combine this with our other veterans offenders bills as one?
We talked about that and this one's a little bit more unique from it. So within that conversation, we felt like keeping them as two separate things.
Who's we?
What I discussed with Morgan and we discussed with MK and we discussed while we were doing agenda planning and things of that nature, the plan to keep these two bills.
Yeah. It should stand alone, I think. Because it's very unique. I mean, the other things all have their uniqueness too, but this one's very, I'm not an attorney, I'm not coming up with the words here. Throw me a lifeline. Anyway, yeah, I just think it's, there's some things that need to stand alone, and I think this is one of those because of the way the language is and it's such, just my opinion.
Rebecca.
I can add a little bit to that. It's not just talking about governmental agencies, like some of the other pieces of the omnibus bill are. This is actually talking about a company, private company. So it's probably better not to muddy up one big bill with extra pieces.
Any other conversation on this one? How's this? Oh, I'm sorry.
More testimony. I just looked at the Tennessee bill's only been enacted for half of a year and some of the loopholes. I just want to make sure, sorry to like keep harping on about this, but the part that I asked about on a veterans benefits matter, there is some concern that people are now masquerading as like coaches and not saying that they're representatives, and that's how they're skirting around this language. So I just want to make sure that if that language is directly pulled from Tennessee, that's one of the areas that they've said that they're having issues with. Because people are like it says advise, assist, or consult. So they're not calling themselves consultants and they're not calling themselves advisors, and they're not using the word assist. They're saying like, we're coaching you, but they're doing the same stuff. So I just want to make sure that our language is super tight on that so that we're not running into the issues that Tennessee is running into right now.
I think that's a very valid question.
If we add some more words to it.
I actually can. So we've been working with the,
Could you just like re-identify yourself?
oh, yes, I'm sorry. Would you like me to come back up to the table? Sure.
Yeah.
Pleasure.
Yeah.
For the record, John Blumstrom, Mr. Chairman. So we've been working through our trade association, the National Association for Veterans Rights. As soon as states are passing these consumer protection laws, our trade association is working with the consumer protection divisions for each AG's office in said states. So North Carolina, Tennessee, South Dakota, Oklahoma, Florida. The first step we do is go to the AG's office and very clearly help define what all of these, to your point, advise, assist, consult. And we help close any language loopholes so that somebody, to your point, can't say like, oh, I'm a coach. It's less about the title for the veteran than it is about the practice, and which is where the consumer protection guardrails come in. That's where we see the real nefarious actors, where it's like charging in perpetuity. There's an actor out there that will essentially if you decide to work with somebody else, there's a clause within their contract that states that they still get paid even though they didn't do the work. That's legislated out here as part of the disclosure language. And again, we are more than happy and willing to come to the table and help clearly define that. Our trade association is very stringent in terms of its certification process. The head of our trade association is a former VA chief of staff and acting secretary. So very aware of the practices that are predatory. Did a lot of work with their OGC as well as the OIG at VA. But more importantly, has identified these practices, and this is what we are trying to proactively legislate out. So that, again, to your point, there's no ambiguity in this, and that we close the door. So the first thing, when H103 passes, our first calls can be to AG Clark's office and their Consumer Protection Division. And we will get hot on ensuring that any loopholes, which there really aren't any, but identifying those practices that may not be covered by the statute.
That covers that.
Okay.
Yeah. That's a good question. Glad we didn't have to get players in the room.
Yeah.
Absolutely.
Don't tempt me with a good time to come back up to.
Let's get him to do that.
We've touched Josh as,
Off the record.
Talk to them.
I've had conversations with Todd Delos about this legislation, but have not had a sit down with the general herself.
Okay, but the conversation was had with Todd. Okay. So they're aware. Have they had an opportunity to review the new language?
I don't know if I've sent the most recent update. Certainly when we, in disclosure to your committee, there were efforts at language modifications back in December. I believe a copy of that bill was sent to Todd, but not the most recent. So that came
The
out
blue line one you had
Yep.
originally. Okay.
in the last couple of days.
And Rep. So.
Should we have them, just because if they're gonna be charged with enforcement, I think it makes sense to have people who are doing the work.
My head. My head was on the same.
Station.
That gives us, and like I said, I did schedule it for Friday in case we did want to hear from other folks or have any changes while we had this conversation. So hearing from them, we'll put that on the schedule before the vote.
Mr. Chair.
Oh, I'm sorry, that was Bert.
So as Bob Burke helps from the paper, so as John had explained and Rep. Stone's concerns, I think the aggregating offenders are going to come up with any sort of terminology that's not in a bill to try and skirt the requirements. So you can't include every potential scenario, word, synonym. People are always, the bad players are always going to press the issues. So I think it's up to the Attorney General's office to really understand the intent, which I think is fairly clear here, so that you can't say, I'm just a coach. I'm not advising, I'm not consulting. I think it's pretty clear from a legal standpoint that it's all inclusive by reading.
Yeah.
Mr. Chairman, if I may, I was just going to add to that. The other part of our engagement with the Consumer Protection Divisions for the ED's office is identifying actors in the space that aren't currently in compliance with H103 where to pass.
Understood. So what I want,
I just had a question that I don't know who it's for. If you have a financial advisor, they have to take like a series of tests. And and stuff to help people manage their money, like there are, certificates that you have to get. Does that apply in this case for?
Please.
Yeah, thank you. Thank you, Mr. Chairman. For the record, John Blumstrom. Want to be very clear. So Mr. Burke was absolutely correct, and that's part of our disclosure is saying that we are not accredited. However, and I can only speak to our company. I can also speak with good authority with Mr. Hollis's company. Part of our training standards are very rigorous. It's 80 hours of instruction by members of our staff that are formerly accredited VA, VSOs, or again, advisors who have done this. So while we may not be accredited, our training and education standards are pretty rigorous, as is our annual audit by the National Association for Veterans Rights. So Peter O'Rourke, who comes in, he's the head of our trade association. He conducts an annual compliance audit, not only on process, but also on training and education, reviews the syllabus to ensure that while we may not be accredited, we're following the letter of the law where accreditation, compliance, and training is concerned. But it's really comparing apples to oranges. I mean, we're not accredited VSOs, but our personnel go through very similar training to what the VSOs do, with a focus primarily on the initial disability claims. I think it's very important to articulate that VSOs run a myriad of functions to include initial disability claims. And Mr. Burke hit the nail on the head. They have to do aid and attendance, pension benefit, death benefits, GI Bill. I mean, there are so many other functions that the VSOs perform. We're of the mantra of do one thing and do it well, but do it well transparently. So again, ensuring the most up-to-date training standards are adhered to, again, under NAVR certification and oversight. And I think it's important to contextualize this too, that at the federal level, we are working with Congress on accreditation reform. Now, I know we'll all chuckle at that because it's Congress, but we're working on federal accreditation reform at the federal level so that companies like ours can become accredited. So we're not sitting here saying we don't want to become accredited. We're actually working at the federal level with Congress to become accredited. So again, we've done this in other states, would have no problem here if it were to come up saying that, once accreditation reform is passed at the federal level, companies that continue to operate in space have to become accredited. We'll be the first ones to raise our hand and be.
Thank you.
Yes, ma'am.
Any other questions on this topic? Thank you, sir. So
Taking more testimony.
what's that?
We're taking more testimony. I just have more questions, but I don't think we have time, just about like how they calculate their fees, whatnot. But we're in the weeds, but still important.
I honestly, we still have 5 minutes here. Let's
1 minute on that.
You can do that now. Absolutely. Please, sir.
Mr. Chairman, again, for the record, John Blumstrom. So there are a couple of there's some background on the fee structure. So the way that our fees are modeled is basically after so the federal legislation, the Choice Act, which is HR 3132, mandates 5 times the monthly increase or $12,500, whichever is the lesser of the two. Our typical fee is in the realm of $2,500 to $3,500. Very rarely do we ever get up to that upper echelon. That's just it's basically just to align with federal law.
And do you collect those fees before a VA decision's made?
No, ma'am.
No.
It is all, and I think the beauty of H-103 is that it's also contingent upon, the fee is only collected if it's contingent upon a successful outcome. So if the veteran, not to go too far down into the weeds, as you say, but if a veteran receives, let's call it a 6-point increase in their disability from 87 to 93%, they're still being paid at the 90th percentile. We don't collect a fee on that because there's no change in the financials. And so I think it's want to be very clear about that and stating that we will only charge once a veteran has received a favorable RDO.
Morgan.
And John touched on it earlier, but just to drive home to And again, we would have to, some of this is in good faith, but in talking with his specific organization, who he represents, that if somebody is in a financial stature position, that they, at the end, they look at it and go, yeah, 5 times what I got, it's $5,000.
Yeah.
But he goes, that veteran says, me giving you $5,000 is the difference between me paying my mortgage for the year or something. I have to take in good faith that they're going to try to work a less than that position. You're going to try to work that veteran.
I want to be
Did I hear
very,
you correctly on that?
Colonel, that is a great characterization. And I want to be very clear. We will not put a veteran in a worse circumstance than when they came to work with us. We will also work with them on any payment plan. If it's $1 a month, if it's $10 a month, if it's everything upfront after the successful completion, we'll work with them on any payment plan, but we'll never put them in a worse off situation. We just don't work that way. We also don't work with creditors or debt collectors. We don't have access to their financials. This is a completely voluntary payment.
Thank you.
Anything further on this one? No later. Okay, thank you, sir.
Thank you.
Okay. Okay, shifting gears to budget letter. Thank you, council. So. Thank you, sir. So shifting gears to the budget letter. We wanted to hear from some folks about a couple of line items, and I see Mr. Gresham is here with us. How you doing, sir?
Fine, thank you.
We'll open up with
Is that an invitation?
That is an invitation. You read the tone correctly, sir. Yes. Welcome. You don't get to see all that often in here.
I think this is a first for me.
Welcome to the new digs.
So, huh?
So, muting. All right, cool. Good. Interesting little technical hiccup there. So yeah, we were going over stuff for a budget memo. So we just wanted to reach out and just get a better understanding of like the nuance within the request. So thank you for joining us. And for the sake of time, the table is yours, sir.
Thank you. Looking first to share. I think you have the budget presentation for both the lieutenant governor and the governor's office. I thought I could put it up on the screen, but I'm not doing something wrong.
Committee may not have it.
It's on the page.
Is it?
I have it up.
Good.
Which one are you looking at first?
Let's go for the lieutenant governor's office. And if you go to the screen where you see the, what the goal of the office is, and it shows you the fund sources there. I would be working off of that. And I think the important thing to cover with the lieutenant governor's office is this is about as simple budget as it comes. And, there's 2 FTEs and there's an office, a very nice room down on the first floor of the State House with an outer room, which I think you're familiar with. So the funding for the lieutenant governor's office is basically the salaries of those 2 employees, the lieutenant governor and his assistant, and the various benefits and the like, as well as fee for space for the office, and that's it. Unusually, the lieutenant governor's office, or lieutenant governor's budget is down 7.5% from the prior year. I say unusually because that's very rare that we have budgets that are reduced from the year before. But as you'll see, if you go to the attachment B, which is, I think, on the next page, I believe, you see an ups and downs. You see the ups and downs. It's a little Excel sheet right there. Yeah. So on that sheet, what you'll see is there are two items that's particular are reduced. One is health insurance, which is down a cool 70% or $36,000, and retirement, which is another line item, which is down 29% or $15,000. That is entirely due to the choices made by the two people in that office. So there are times when that goes up if they choose a more expensive health insurance operation, typically if they have a family plan versus a single plan. Or some people opt out, they go with their spousal plan. So that's, again, entirely essentially a roll of the dice. This year, it turned out to be favorable. So the down in, and retirement will also vary depending on the choices they make. The exempt employees have the option of a defined contribution plan or defined benefit. Classified employees are a defined benefit only, but exempt employees have an option. And to the extent that they choose a DC, a defined contribution plan, that will be less expensive overall. So that's why you see savings with retirement. So the two of those downs were more than enough to cover what's a little over 6% increase entirely in payroll and some operational pressures, but the net was a little over 7%. Are there questions in that regard?
Seeing no hands.
All right. And then you also have a executive office presentation. This is a little more complicated, although I will say not really that much more complicated. The executive office is the office that includes the governor and his staff. And the executive office budget is up about 5.3%, which is a combination of a 4.4% general fund increase and an 8.8% increase in what we call IDT, interdepartmental transfer. The net of that is a total of 5.3% up. The fund mix, now remember the lieutenant governor was all general fund. The fund mix in the governor's office is a little different. It's predominantly 78% general fund, but it's 22% interdepartmental transfer, which is a fancy way of saying some departments are, he allocates out a portion of his expenses to agencies and departments that he serves. So that's makes about 22% of his total budget. So again, the vast majority is general fund, 78%, 22% is interdepartmental transfer. The total is $2.66 million for the governor. This office has 14 FTEs, 14 in total. That includes the governor, his chief of staff, the secretary of civil and military affairs and legal counsel, as well as other people with lesser titles. In his budget, if you look at the same ups and downs spreadsheet, in his budget, there are small savings in healthcare, which again is entirely choice specific. Amongst his staff, there's a small healthcare savings. And there also, somewhat unusually, is a small savings in ADS charges. You don't hear that very often. Generally, you hear the reverse. And this is actually a little bit of a story. And that is that last year, the governor's office was over budgeted for the SLA, the service level agreement. Those are bills that are sent out on demand when software is used or when services are used that are not typically used across state government, but specific to that department. But the budget for the service level agreement last year was set at $65,000, which was substantially higher than need be. So this year we set it closer to actuals, which was about $20,000. So about a $45,000 savings in the service level agreement, which was enough to overcome a substantial increase in the ADS allocated storage. So the net of it is a small savings to ADS charges combined with a small savings in healthcare. The only thing I think is really unusual to point out here is there's a substantial increase in vacancy savings in the governor's budget. And vacancy savings are when we anticipate that not all positions will be filled, rather than budget for them to be filled, we save that amount. And that shows up as so-called vacancy turnover savings. You know, the governor's office has 14 full-time equivalents. There are currently 10 positions that are filled. And that was actually true last year, and the anticipation is it will be true next year too. So we're budgeting for 10 positions that we anticipate will be filled, and 3 to 4 vacancies in that budget. So that's why you'll see that vacancy savings, which were kind of under budgeted last year, this year are being budgeted at what we think is the actual, close to the actual amount. So that with that increase, as well as smaller savings in healthcare and ADS, that was somewhat able to offset other increases, standard salaries, standard operating costs. I'm out of things to say unless you folks, again, like I said, it's a fairly simple budget, but I'm happy to answer any questions you might have.
Questions? Yes, Representative Waters Evans.
Hi, thanks. So I was just looking at how it says there was an increase in personal services of a total of $130,350.
Right.
And I'm looking at the spreadsheet and even, so does that count even with the decreases from the vacancy turnover? I just wanted you to explain to me what that $130,000 was for.
You're talking about the governor's budget?
Yeah.
That would be salaries, that would be typically payroll, personal services.
Okay, so out of the 10 people who are there, their salary increases totaled $130,350?
That would be the net increase. Yeah, I don't have that in front of me, but that sounds about right.
Okay.
Any other questions for Gresham right now?
Mr. Chair, I think you had requested some words from or testimony from Douglas Farnham, our Chief Recovery Officer. And he is hopefully enjoying himself somewhere warm and pleasant, but he is on vacation this week. So the Secretary of Administration said that since I'm somewhat familiar with what they're doing, that I could at least give you a few words. I think you had some questions regarding the July 10th, 2025, the July 25 flood.
Yes.
Which came a year after the July 24 flood, which came a year after the July 23 flood. There's something about July 10th that makes us all nervous. So this was somewhat unusual in that it was very targeted. And you'll recall that the state had, as we had in past floods, applied for FEMA disaster declaration. We gave them a $1.8 million estimate, which was well over what the requirement is for FEMA assistance. And to our surprise, we were turned down. So we appealed the decision. And to our surprise, again, we were turned down. So that is final. So the $1.8 million disaster estimate that we filed with FEMA, typically the way that works is right after a disaster, we reach out as quickly as possible. We go to the affected communities. We, with Vermont Emergency Management, often with the Agency of Transportation, because a lot of the damage, or some of the damage anyway, is often roads and bridges and the like. And we make first kind of quick estimates. That was the $1.8 million. after the declaration is declared, part of FEMA, they will send their experts who will work with our experts. We'll have a lot of boots on the ground and we'll fine tune those estimates. That is what's going on now, absent the FEMA folks, but AOT and emergency management are in these communities. And their most recent estimates of damage from the floods are $2.9 million. There are 5 communities affected, East Haven, Sutton, Newark, Burke, and Sheffield. By far, Sutton is the most affected. Of that 2.9 million, I think over $2 million is Sutton alone. And these are, traditional, I hate to say that term, but traditional damages. You have bridges, you have culverts, you have roads, pavement, and the like. So of that 2.9 million in estimates, a little under $1 million as of, I think, last week was spent by the towns, in part because many communities don't have the luxury of just waiting around for a check to arrive. I mean, if these are important components of the town infrastructure, they need to repair them first and then worry about how they're going to pay for it later. So that's what's happened. There's been a little under $1 million already spent. AOT, the Agency of Transportation, and Vermont Emergency Management are working with the affected towns to fine tune estimates. Again, the current estimate's about $2.9 million. And they're also working with the Recovery Office to develop a plan for assistance. And the plan is to put recovery needs and potential language, if it requires language, into the fiscal 27 budget. So our intention is to feature in the 27 budget. It doesn't currently, because when we submitted the governor's proposed budget, we were under the impression that this would be declared a disaster. So how we provide relief and how much relief to provide, I think are questions this committee would be very interested in. I can assure you I'm very interested in that too, and that's an active discussion. But that is where it stands. I believe by the time the budget leaves the House and heads to the Senate, it will have in there, or we will propose to have in there, some relief for the communities.
Representative Hager.
Thank you. Since we're also working on a bill that has to do with emergency management and disaster relief and working on our budget, how do we make a recommendation not knowing what you all are going to ask for in the budget?
I have no good way of answering that. What I will tell you, again, keep in mind for context, I'm the finance guy. So I think about it in terms of digits. And I think the closest estimate now is for total 2.9 million. However, whether 100% of that is covered or 50% of that, under active discussion. So I think, again, I would maybe provide an estimate for the House Appropriations Committees, just so they have a heads up. They may decide we don't know enough, we'll kick it to the Senate. I mean, that they sometimes do that, but I would provide an estimate. In terms of language, it may be that, we have a non-federal disaster mitigation fund. It may be that will require some language if we decide to use that vehicle. There's an emergency relief and financial assistance fund, EROP. If that vehicle is used, that will require language. And how the relief is sent out to communities. Is it a granting program? Is it just straight appropriation? We don't know. So that will require language. And again, all of what we hope is all of this we will have for you in a nice, neat package with a bow wrapped on it.
Appreciate that. So you giving us the estimate from AOT and VEM, because until 2 minutes ago, my estimate in my head was $1.8 million. So appreciate you flagging that.
No, thank you for those details, Commissioner. I think I got what I personally needed. Any questions for Mr. Gresham?
Good.
Thank you so much for the time, sir, and helping us.
Thank you for inviting me.
Yeah,
Been a pleasure.
appreciate it. And we are going to discuss the budget letter from the Secretary of State's office once the secretary comes back in. Speaking more to the project at hand with a memo. The goal today is that we complete this project of the recommendations and then be able to submit this to appropriations today for them. So that's why we carved out as much time as we did for this project, the remainder of the working day. So that's the end game, at least as far as the project in front of us. And I guess we'll just kind of hold for a second and wait for the secretary to come back. So
Any thoughts on just taking a position right now on what we just heard for the governor and the lieutenant governor's office, so we can check some boxes while we're waiting?
that, just knowing that the secretary comes in, that will for still. So I guess we could start off with what was spoken to first, the lieutenant governor's budget. Operating costs down 7.5%. I take no issue with that. Unless anybody has any conversation. Yeah. Okay, so I guess I'll ask for thumbs on that one, favorable. Okay. Favorable thumbs on the Lake of. And then questions on the governor's office budget that was proposed. That's. Ooh. Thumbs favorable. You know, yeah, it's the plurality of favorable.
It's not like the race.
Good. It's just a plurality straw poll. All right, Madam Secretary. How are you?
Yes.
Yes, absolutely. Thank you so much for finding the time.
Plenty of time, just can't figure out where to be at any moment. Triple book this afternoon.
Yeah.
Where are your favorite?
Of course, always.
Just check.
Art resides here in HGO.
And so, yeah, just to run through this, we received this on Friday, so we just want to speak to your office real quickly as we're wrapping up our budget memo process. So I know you have places to be, so the table is yours.
I will fly right through this and then take any questions that you might have. I'm Sarah Copeland-Hansis, your Secretary of State. There is one change to our initial budget ask that is contained within the letter that you have in front of you. So I will just reiterate that we are asking for the typical $450,000 in support from the General Assembly for the conduct of elections. We had initially thought that we also needed to ask you to help backfill some of the missing federal revenue. We typically get around $1 million a year in federal revenue. Last year it was $272,000. So we initially asked if the legislature could help us backfill that. However, good news, happy news. We are about midway through the annual report season in our Business Services Division, which is the division that brings in the revenue that the Secretary of State's office runs its elections division and other divisions on. Those revenues are coming in just as strong as they did last year. So knocking on wood, if I'm assuming that the same pace of business filings will continue through the end of this first quarter, in which case we feel confident that we can say we do not need that extra $650,000 that we had asked for in our initial budget ask. when we testified to appropriations on February 5th. So contained also within our budget ask and within this letter that you have in front of you is the Democracy Media Grants. These are grants for the Vermont Access Network, the Community Radio Network, and local journalism. I'm happy to talk in more detail about those programs if you'd like to, but I understand you have a time crunch on finishing up your budget memo, but the Secretary of State's office does strongly support those grants to help keep our local media infrastructure strong and vibrant in this state. There are a couple of provisions at the end of this letter that don't have a fiscal impact, but that we want the Appropriations Committee to be made aware of. You created for us a limited service position in 2025. That was to double the size of our municipal services division. We help Vermonters across the state and municipal governments across the state understand how to comply with state law. And we do a fair number of trainings on open meeting law for boards around the state. And so that extra position that you made for us last year, we would like to have that made permanent. We believe that we have the revenue within our Secretary of State funds to cover that. And then we're asking for 2 full-time positions, 2 new positions, 1 position at Vasara, a full-time position within State Archives and Records Administration. Again, no fiscal ask. We need an extra records and information management specialist to focus on implementing records management for state agencies and departments. And we would also ask for another position in our business services division. This division is a small but mighty division that has a touch point on every single business and nonprofit in the state. And the workload that they bear, particularly during this first quarter of the year, but really throughout the year, is really tremendous. And we feel that we need another position within that division to help manage that workload. And then finally, at the end of the letter, we talk about the creation of a capital IT fund. I know that I've talked about this in front of your Energy and Digital Infrastructure Committee. I'm not sure if we've talked about this in front of your committee, but increasingly the IT systems that we use in the Secretary of State's office and indeed across state government are really the access point, the front door, if you will, where Vermonters can go to get those government services. We want that to be a smooth and seamless process. We want there to be no barrier to people being able to do whether it's renewing their business registration or getting their nursing license. But these are big and expensive projects. And when I became secretary, we had 4 existing IT systems that needed to be replaced. That was a really big budget hit across only 2 budget years. And I think it is in the best interests of our office and Vermonters that we start putting away a little money each year so that we have a capital fund, reserve fund set up so that if we get 5 or 10 years down the road when these systems need to be replaced and we're having a tough budget year, we don't want the quality of service that Vermonters expect to suffer because we hadn't planned ahead. We know that there's a life cycle for IT systems, and we know that if we can put a little bit aside now, it will lessen the sticker shock when we need to replace these systems in 5 or 10 years, and it feels the fiscally prudent thing to do. So that's the last of the items in our letter that was sent to the committee on Friday, and I'm happy to take questions.
Rebecca.
Just for clarification, because I was having trouble keeping up because I've got 2 different spreadsheets, but the letter.
I'm sorry, I was talking fast.
No, it's fine. The full-time position within the business services division, is there a fiscal ask?
No,
That, okay. And same thing with the Visara one?
that is correct.
Rebecca.
In your ask for I just want to make sure I'm not talking the 1.8 million for the VAN and then the 90 for the community radio, don't we already have that on our spreadsheet?
We do.
Okay.
I'm just trying to find what page it's on.
I found it
is
on the second page.
Yeah, it is within the Secretary of State's office.
Okay,
So yes.
I just want to make sure it wasn't an additional 1.8 and another 90, okay.
Goodness, no.
They came to us separately and the 1.89 contains
The 90.
the 90.
Right. Okay, and then one other question I have on, maybe it was answered. No, that's fine, I guess whatever it was, it's gone, so it's okay.
Okay.
And just to be clear, your ask is $450,000 plus 50,000 for the local civic journalism awards and not taking into account the van request because we have that on a separate line item. So 500,000, is that?
I am not sure how your spreadsheets are organized, and so that's why we wanted to put all of the things that our office supports into one memo. So the fiscal impacts are the 450,000 for elections, 1.8 for van, 90,000 for community radio, and 50,000 for the local journalism grants.
So that's where my confusion is because you just broke out the 90,000 separate from the 1.89.
Mhm.
And for whatever reason, I thought the 90 was included in the 1.89.
I don't have access to the document looking at. So I don't-
No,
Then-
so it is a separate. Community radio 90,000 is separate from the 1.89.
Yes,
No, okay,
No,
it's in it.
okay.
it's the
That's all-
1.8
all
plus
I
the
need.
9.
Yes.
So it looks like we have a $1.89 million ask and we have a $500,000 ask.
Yes.
Okay. That's all we need. Thank you very much.
Anything else from the secretary? Thank you so much.
Pleasure to be with you this afternoon.
Yes, and I want to call for a break until 2:30. And then we'll come back then to pick this up. I need to go make a phone call on another bill. So Nick, take us off till